Good morning, everyone. Again, thank you so much for joining us this morning and happy Aloha Friday. Today we have with us, of course, Jessica Pascua, our senior escrow officer. She's going to be navigating us through the special circumstances that can come up in escrow transactions. And we'll open it up for questions throughout the session. So please don't hesitate to ask away. And without further ado, Jessica, take it away.
Thanks, Tam. It's been a while since I've seen a lot of you, especially working in escrow side of it now. I hardly ever get to see anyone, but it's my pleasure to be here with you all and go over some of these interesting situations when it comes to land court system versus regular system and the different things and challenges that might occur. This class was actually suggested by one of the agents in the Hilo office. So thank you. We encourage any type of needs and wants that you guys have out there. You know, we'll put something together for you, something similar to this, and just to help you out. So let me see if I can do this screen share. Tam was great enough to help me out. Hopefully I don't screw it up. Can you see my prelim? Yay! Tam, you're awesome. All right. So, and let me know, stop me at any time if you think I'm going too fast, because I have the tendency to ramble on. First thing I want to clarify is the difference between regular system and land court, and how you can tell on your prelim which one it falls in. So this is an example of a title report. And on page 3, this is where the vesting will appear of who the owner is. When it says document number, and or it says book page or LIBOR page, that's your clue that this property is recorded in regular system. Okay. Regular system is the regular system recording department. They'll record anything. You send in a document to record, they'll record it. This here is an example of a piece of property that is recorded in land court. And you identify it by the fact that it actually says land court document. Okay, so regular system, it'll be a document number or it'll say book and page. Land court, it'll actually read land court document number. And that's how you can identify if that listing is recorded in land court. Now, so those are the two systems that we can do recordings in. Then you come upon the fun properties where it's dual system. So these properties are recorded both in land court and in regular system. And accordingly, your recording fees are gonna follow which system it records in. So regular system, they have their own recording fees for recording a document. Land court does also. The fees are different in land court. So this is an example of a piece of property that is recorded in dual system or both land court and regular system. With land court, it's a lot stricter. They're a lot stricter in what they record. Unlike regular system where any person can just send in a document and get it recorded in regular system, with land court, your documents actually get reviewed. When there's a transfer of title, they don't just record the conveyance document. They actually issue a TCT or a transfer certificate of title. So it's an additional document whereby they're confirming this property was transferred from one owner to the other. With land court, it's a bit confusing because there's technically two arms to the land court system. The first arm is the judiciary arm. So there's a judge, and the judge appoints a registrar. So when you send your document in, okay, back it up. Let's say your title is in trust. And when the deed was recorded, John Doe was the trustee of the John Doe Trust. You're now going to sell it, but the new trustee is Jane Doe because John passed, right? With regular system, as long as the title company is provided with copies of the trust and who the successor trustees are, it's good. We can record that way. With land court, whenever there's a change in title, and that can be the change in who the trustee of the trust is, marital status, name change, anything that'll affect the title, you need to petition the land court judiciary arm. And what you would need to do is you would file a document called a petition with the land court that'll have exhibits to prove the change in the titling, whether it's a marriage certificate, a death certificate, trust documents to show who the new trustees are. Those are all added to the petition as exhibits. And it needs to be originals. This is then submitted to the judiciary arm of land court, where it is reviewed. And once approved by the judiciary arm, then escrow knows you're good for recording. I'm going to stop there. That was a lot of information. Does anybody have any questions so far?
Just when are you recording? So if it was in land court, I understand you have to get that, but are you still doing land court today, or would you go to regular system?
So you can now deregister, an owner can actually deregister their property from land court if they wanted to. If it's currently in land court and they don't want to keep their property in land court, there is a system, or there is a way that you can get it deregistered from land court. I've never gone through that process. I don't know how hard it is or how lengthy it is, but you are now able to remove it from land court. But once a property is recorded, whether in land court or in regular system, that's the system it's going to follow for the rest of eternity. Does that answer your question? Okay. Anybody else have any questions?
Jessica, hi, it's Gary.
Hi.
Why would someone record in both land court and regular system? What are the advantages?
So a lot of, when you see it in dual system, land court came into play, I don't exactly remember the year, but it was a while after regular system was already in existence. So those developers that decided to put it into land court, because it is a stricter and more rigid and very clear-cut system, they ended up recording the property in both regular and land court. So those properties that are just in land court system, they either remove themselves from regular and put it into land court, or just when it was newly subdivided, put it into land court, and it moved forward from there.
So one last question. you mentioned that there are 2 recording fees. So if someone is purchasing a property that has, both land court and regular system, we need to make sure they're aware they're going to see 2 recording fees on their closing statement.
That's correct. Well, it'll be lumped together, but that's correct.
Yeah, it'll
It'll
be
be
a
much
larger
higher.
fee. Yeah.
It'll be much higher, yes. So with regular system, it's $41 per document. With land court, it's $36 per document. But when you're recording a conveyance document in land court, there's also the $50 TCT charge for the original transfer certificate of title to be issued.
Mhm.
So in land court, technically a deed is $86. That includes the issuance of the TCT. So yes, if it's in dual system, then you're looking at 86 plus 41 just for the deed.
Right. Thank you very much.
You're welcome. Good questions. Anybody else?
I had a quick question.
Yes.
If somebody did make the change from land court to regular system,
Mhm.
how would that be known on your side if that person decides to sell the property? How is it discovered?
Again, I have never gone through the deregistration process, but I'm pretty sure with the application, there's documents that must be filed with the systems so that when a title company pulls the documentation, they'll see the transfer, the
Okay.
deregistration. But I can get, is that Michael?
Yes.
Asking? Okay.
Mhm.
I can get that question confirmed for you.
Thank you.
You're welcome. Just writing a note so I don't forget. So my suggestion is when you take a new listing, get that comp prelim as soon as possible, even if it's just a future listing, only because when you have to file something with the judiciary arm, unlike the recording arm, so when escrow submits a recording packet to the state, it's going to record 2 days later, right? They review it and then it records on the second day. When doing filings with the judiciary arm, where you're proving to them that there's been a change in title, there's no requirement of when they need to look at it and get it approved by. There's only one land court judge who appoints one land court registrar on the judiciary arm.
I have a question.
Yes.
Okay. If the seller marital status change, and then also the name change because of the marriage, and then after that, husband died. So do they have to make 3 petitions for the name change and a marital status change, and also this, husband's death?
That's
Or
correct.
can be in one petition, all those 3.
It's all separate petitions.
Oh, God. So it costs all, cost just added all 3.
Right. Well, so the name change in the marriage could be done in one.
Okay.
It's 2 separate actions, but affecting the same person technically, but the death would be a separate petition.
I see. Thank you.
Yeah. So when you pull your preliminary or your comp prelim and you're talking to your sellers, review the comp prelim with them. They may not even be aware that when they took title, they were unmarried and now they're married. Or, I had an interesting situation where a client, when they bought the property years ago, his legal name was Stephen with a PH. This was back in 2012. We're now in 2022. In the meantime, he had to get a driver's license. That's when he discovered on his birth certificate, his first name is actually spelled with a V. So he got all of his documentation corrected. His ID now reads as V. So when he goes to notarize a document, that notary is going to acknowledge him as Stephen with a V, which is different from how he took title, right? Which is Stephen with a PH. So even simple things like that, your owner may have owned this property long enough that they're not even aware that there are changes that need to be addressed. And again, if it's regular system, it may not be as difficult. But if it's land court, you're looking at time here in getting things corrected. With land court, they don't allow, your legal name has to be used. First, middle, last. If you have 3 middle names, they all need to be on there recited. With regular system, they're not as strict. So with land court, even if it's let's say there's a couple getting married. I mean, a married couple, but only the husband is going on title and the property is land court. It is required that we recite marital status and the name of the spouse, the legal name of the spouse, even though they're not going to have any interest in the property and they're not taking title to it. With land court, everything has to be fully spelled out. With regular system, if it's just the husband going on title, we can just say they're a married man. We don't have to recite husband of Joan Smith. Right? So these are the kind of things that you want to be aware of when dealing with any type of land court versus regular system properties. When you're representing a buyer and it's land court or dual system, your buyer may ask you, why is escrow wanting to know what my wife's name is? This is the reason why. And of course, that's what we're here for. So if you ever have any questions or anything like that, always feel free to reach out to us so that we can help you clarify this. But when you take your listings, if there's any way possible to get any of these petitions filed prior to it even going into escrow, that would be great. So your worst situation is where you have to petition, and on the buyer side, you have a loan. So you're working with a lock expiring and having no control of what land court is doing with the filing of your petition. So once the judiciary arm in land court approves the petition, they will actually file it electronically in the courts, First Circuit Court. And I think I have an example. Sorry. Put it towards the end. Nope, not that one. I hope you guys aren't getting dizzy. Not that either. This is going to be really embarrassing if I can't find my filing. So this is, thanks Christine for laughing. This is an example of a petition that was approved by the land court judiciary arm. So once the judiciary arm approves the petition, they will actually file it electronically in the circuit court. Then they'll return it to the title company, who let escrow know, hey, your petition has been approved by land court. You can now move forward with recording. Okay, so the second arm of the land court system is the recording arm. And this is headed by the assistant registrar. Okay, so the judiciary arm is headed by the land court judge. The recording arm is headed by the assistant registrar. What really becomes confusing is it's both called land court something, right? But what you need to know is that each arm is actually governed by a different government branch. So the judiciary arm is governed by the judicial branch, which is the Chief Justice. And then the recording arm is governed by the executive branch, which is the governor. And I might have given you more information that you needed, but that might clear up when we talk about land court, filing a petition, recording the documents. It's two separate arms that we're working with, right? And yes, just to let you know, you may file a petition with the judiciary arm. They approve the petition, right, with their filing. You go to record, and the recording arm rejects the petition. I've actually had that happen. So it was I had a successor trustee involved in this trust. We filed the petition with the land court judiciary arm. They approved it. They filed it in the First Circuit Court. We move forward with the loan and everything. I submit my packet, and the recording arm rejected my approved petition that was approved by the judiciary arm. So we had to redo everything again. The file extended for about another month and a half. Luckily, the lender, the buyer, everybody was, willing to hang in there, but it took us that much longer to get that file recorded. Does anybody have any questions of what I just went over? So again, this is a sample of the exhibit of a death certificate. Now this one I pulled up, I'll just hit on it real quickly. This one was actually done in Japan. And in Japan, your documents, there's an apostille that's done instead of it being, most times instead of going to a US embassy where a notary would do it. The apostille is in Japanese, and not everybody can read Japanese, right? The good thing is in Japan, their apostille is also put in English. So in Japan, they're very familiar with these kind of notaries and documentation. When these documents come to Hawaii for recording, the recording department needs to be able to read what this document says, right? To be sure that this is a clear document. I understand what it is that they're authenticating. I have a situation on a file where the apostille came in and it's in French. We don't read French. I can't. So now our file is on hold while we get these documents translated into English. So those are just some of the things that you might want to be careful of and aware of, especially with land court if your clients are foreigners or, not here in the US where they can easily go in front of a US notary.
Jessica,
Yes.
Gary here.
Yes.
Just quick question. In today's little bit crazy world, how much longer does it take to run through a land court recording than a regular recording? Or is there a difference? I don't know.
Not for recording. There's no difference for recording.
Okay.
It's just when you have to file a petition with the judiciary arm because of a change, it was really bad. It was taking up to 6-8 weeks, especially during COVID and stuff. It has gotten much better. So the quickest I've seen happen so far with a filing of a petition was just over 2.5 weeks from the time the original was submitted.
So that So when you are recording from a seller to a buyer, that's not an additional petition. That's just a recording of a transaction that doesn't have to go through that other process.
Correct.
Okay.
Correct.
Yeah.
Yeah, the recording of land court and regular system is the same. It's just when it's land court and you have to file a petition, then you're looking at potential wait time.
Yeah.
Yeah.
Okay.
Yeah.
Great.
So
Thanks
if
for clearing that.
you're welcome, that was a very good question, Gary. So yeah, if any of this can be cleared up ahead of time, that would be great. So even something like with land court, a power of attorney is being used. You want to get that power of attorney signed, notarized, and filed with the approved by the judiciary arm before you're even looking to go, you know, towards recording. You want to make sure everything is perfect on it, because you'd hate to get to the very end and it get rejected for whatever reason. So communication is key with the sellers on your property as well as with escrow. I had an example of an estate. So this is a title report, which was really nice because it was owned by an individual who passed. And that person now no longer has the ability to sign because they're no longer with us, right? So it has to go through probate. And when we pulled this title report, we were able to see, we whited out the name, but it already reads the estate of. So the owners of this property had already been working with an attorney to file probate, file court documents with the courts, so that we can see here on this title report that this is pending a probate that was filed back in 2020 with the Third Circuit Court. So there's paperwork already filed with the courts. Title can clearly state that this is the estate of the owner. We have been provided documentation. Sorry. From the seller that have been filed with the court system that lets us know who it is that is authorized to sign on behalf of the deceased seller. So with title being held by an individual that passes, probate can take months sometimes. The little heads up that I want to give you on when it comes to probate is where the owner is, this was investment property here in Hawaii from them, right? So they filed probate documents in the state where the owner passed. For example, the owner was a California resident. They passed away. They filed probate documents in California. Those probate documents filed in California will not work for the Hawaii property. Probate documents also have to be filed in Hawaii with the Third Circuit Court. So again, when you take that listing and you know it's an estate, especially if it's an out-of-state seller, make sure that the probate documents not only have been filed in the state that that person resides in, but also in the state of Hawaii, because that could cause a delay as well. Probate can take months sometimes. Any questions on this section?
Jessica, can you also touch bases on how land court will sometimes reject documents from foreign countries as well? I know they don't necessarily, if a client does a name change or gets married in a foreign country, land court sometimes will not accept marriage certificates from foreign countries.
That's correct. That is correct. That could be challenges you're looking at. And again, most times those certificates will not be in English. So again, it needs to be translated. Which costs money because you need to hire a professional who will actually translate these documents into English. So being aware of and asking for documentation up front is really, really crucial. That way, any issues that come up can be addressed way before you're in a binding contract with timeframes that could, you know, potentially turn into a nightmare.
Jess, is it going to probate because they didn't have a living will and the property wasn't in a trust or an LLC? Is that why?
Correct. Yeah, title is held is in an individual's name. So what we need to do is we need to find out who is now authorized to sign on behalf of that deceased person. And when you go through probate, one of the things they do is they find all the heirs of this person, right? Make sure everybody's aware of the death and there's not going to be anybody coming back later on and trying to file claim on a piece of property because they think they have rights. This report here is an example of a piece of property owned by a husband and wife. That husband and wife recorded a transfer on death deed. This is one way to avoid probate. So this document has been recorded by the owners who hold title as individuals. When the death occurs of both sellers, this transfer upon deed death takes effect. So the person that they recite in this document is now the new owner. Isn't that cool? Save on money, time, whatever. Well, yes and no. What I wanted to point out on the transfer on death deed, there is an 18-month waiting period upon the death of the sellers before any title company will issue title insurance. Okay, so now to clarify, this person that's recited on this deed is technically the legal owner on title. Okay. But as far as getting title insurance issued, there is an 18-month waiting period, which is what is the law allows for any heirs to come forth and file a claim on the property. So with probate, when you go through probate, you're already proving all of that, right? You're already locating all the heirs. You're already filing all the documents with the courts. The judge approves it and says, yes, this is good. This is the person who is now authorized to sign on behalf of the deceased. We've checked into everything. This is all good. With the transfer on death deed, that hasn't occurred. So you don't have to go through probate. The person listed in this document is technically the new owner. You just can't get title insurance on this property for 18 months after the date of the death of the seller, of the owner. So when you take a listing and the client says, I inherited this property, right? You pull the title report. And let's say James Smith was the person cited in this. This is the person you're working your listing on, right? So when we pull the title report, it shows James Smith as the owner. but it'll recite here that he got title via this transfer upon death deed. So he would have to provide a copy of the death certificate. We would take a look at the copy of that, see when that person passed, and then move this out 18 months. That's when title insurance can then be issued on this. That's when you can technically sell a property to anyone and get title insurance. Any questions on transfer on death deeds?
I got a couple questions, Jessica. So just to clarify, first thing, because if you have a transfer on death deed, I think we need to clarify that does not mean the estate doesn't have to go through probate. It just means that the transfer of title occurs without a probate, but the estate may still need to go through probate. The estate, not just the property. So
Correct.
I want to make it very clear to the agents that it doesn't avoid probate. It avoids probate in the transfer of title of the property, but it does not avoid probate of the estate. That's a clarification. The second thing is, if the probate occurs and is completed prior to the 18 months, will the title insurance companies insure title? If the probate is completed prior to the 18 months?
Probably based on documentation given. I will get an answer to that and get it verified. I'll get that answered for you, Glenn.
Yeah, because I think if the probate is completed prior to the 18 months.
And there's no question, yeah.
Yeah, the title insurance can be granted, but in absence of a probate, it's the 18 months.
Right.
Yeah.
Yeah. Hey, you're a pro on this. You should handle all of these transfer on deed upon death listings.
Unfortunately, I had to deal with all this stuff before, so.
So if you have any questions, go to Glenn.
No, I'll tell you, the one that surprised me was we had a client that was married in a foreign country, and it was in English. The marriage certificate was in English, but the land court rejected it.
What
And
was the reason?
it was because the feds have this rule about marriages in certain countries that people were trying to get married to avoid immigration. They're trying to get married and get people into the United States and put them on title on properties. I don't know if it was money laundering or human trafficking, but certain countries, the government red flags, and yeah, I found that out through land court. They rejected the marriage certificate because they had just gotten married, and even though we had the certificate, they rejected it, so we couldn't close.
Interesting. So they didn't recognize it because it's one of those red flag countries.
Yeah, I was shocked.
Wow.
Yeah.
God, you learn something new every day. Do you need a job, Glenn? Because we're opening up a Hilo office and you can.
So Glenn, they were never allowed to sell that property then?
They were buyers. They weren't allowed to take title as husband and wife, because they were only married for about 7 months, and they were coming from a country where I guess they make online arrangements to get married and, to buy property. I don't know whether it's money laundering or human trafficking issue. They wouldn't be specific, but they rejected the marriage certificate.
Interesting.
Yeah.
That's good to know. That's good to know. They're actually getting stricter with those kinds of international rules and everything. Yeah. Money laundering is a big deal. Let's see. This report is just an example of a piece of property. So it's owned by a trust. What's recorded on there as an encumbrance is the life estate interest, which is further described here. So this is where a husband and wife owns a piece of property, and they want their parents to have rights, not necessarily owner's rights to the property, but rights to live on the property until it's time of their passing. So this is an encumbrance on the property. So when this property is being sold, the deed that will transfer title from the trust to the buyer will include language to release the life estate interest of the person that they were allowing to have interest in this as an encumbrance. In this situation, luckily, well, so the person who had the life interest on the property passed away prior to us recording. So our deed no longer needed to have the life estate interest verbiage in the document. It was going to be a direct deeding from the trust to the buyer. What caused a little bit of holdup, and I say little bit because this is regular system. So this is a library page, it's not land court. What caused a little holdup is that we needed proof of the passing of the person who had the life estate interest, right? So we needed to see something from the state that's issued saying, yes, this person passed. Normally it would be a death certificate. You know, sometimes that takes a while to get copies of death certificates, certified copies. In this case, because it was regular system, what was accepted, and this was issued within 4 days, I think, upon the death of the person, was a state of Hawaii death certificate worksheet. So it had enough information on here to confirm the death of the person who had the life estate interest. And we were able to use this document to confirm the death and then revise the deed so that it removed the notification of the removal of the life estate interest. But we did have to wait a few days. We did have to extend. Any questions on this document or what I just went over?
Jessica,
No?
I have a question.
Yes.
So the regular system may works the worksheet, even the marriage certificate or death certificate. It's because death certificate coming 6 weeks or 2 months, have to wait. So in this time works the worksheet. So
Right.
at
Right,
the
because
regular system.
it was regular system, so we didn't have to file any sort of petition,
Yeah.
right? Or any of that extra documentation that's needed when you need a petition, when a petition is required.
Mhm. Great.
Yeah. So
Okay. Thank you.
you're welcome. I think that's it. I think that was all that I had for exhibits and everything like that to show you. Hopefully that gave you some tips and hints and enough information to help make life a little smoother. And even if it's just an understanding of the timing of how land court can hold up a transaction, you know, getting things cleared up prior to moving it into a contract. There's a couple of things in the chat.
And may I ask, and I'm not an agent, but this brings up a really good question in case I want to share this. So if I'm a listing agent and I get a listing and I get your prelim that comes back and I see that it's land court from what you've shown me, are there specific questions that I should ask my clients right there to make sure that we don't have to petition it? Has there been any changes? Is there something specific that I should ask or look at to make sure that we're ready to go into contract?
Yeah, I actually had a conversation with a listing agent on something similar. So she ordered a comp prelim, it was in trust. And though I didn't see anything strange about it, I did mention to her when I sent her the comp prelim, just reach out to your seller, just verify for them, title is in trust. Make sure that there is no change in who the trustee is that's going to be signing our sale documents. Sometimes there are changes, especially with a trust. The thing to remember with a trust is your owner is an entity. It's the trust itself. It doesn't matter if it's the John and Jane Doe Trust. John and Jane Doe do not own the property. Their trust owns the property. So even if we were to issue proceeds, the proceeds are going to be made payable to the title holder, which is the trust, right? And with any trust, you can have Mary and Bill as trustees of the John and Jane Doe Trust. So I was able to convey to that listing agent, just double check with your seller, make sure that there's nothing that has changed from the time they took title, where it shows that this is the trust name and this is the trustee that signed when they purchased. And it actually opened up some conversation with the seller, because they weren't even sure of who the trustee of the trust is. So now they're digging in their closet to go look and confirm all of this. So even if it's just individuals, when a person purchases, unfortunately, they're not always not everybody scrutinizes the documents that they're signing, right? So if there's a typographical error on their name, or again, they were unmarried when they took title, but now they're married. Those are the kind of things that you should be bringing up with your sellers when those comp prelims come in. Hey, this is what I got. Let's just go over this real quickly and make sure nothing has changed, whether it's land court or regular system.
Thank you.
You're
I have a
welcome.
question,
Yes.
and it might be a two-part question.
Okay.
So let's assume we do a prelim title report, and in there we notice that the wife has passed away. So we wish to petition that.
Mhm.
Who writes the petition and who pays for that?
Good questions. So it's to clear title. So your owner will be paying all of those fees.
Okay.
Um,
Do they go through the title company to do that?
They would actually, if it's prior to an escrow being opened, we normally suggest real estate attorneys that they reach out to directly.
Mhm.
And that real estate attorney can actually move those filings along quicker.
Mhm.
So if it's done prior to escrow, the filings through the judiciary arm, these attorneys can do it electronically themselves, much quicker than a title company could.
Mhm.
So those costs incurred are all taken upon by the owner of the property, and it is done prior to escrow.
But once it's in escrow, if we did need to petition, then that would be a charge to seller.
Mhm, mhm. Yeah, and we would do the ordering of the documents. We would run it all through escrow. Again, it's just, you're taking the risk of it extending in escrow.
Mhm. Then, so prior, you also mentioned, in land court, if it's husband and wife, but husband's on title and, and the wife's name is there, if she were to pass, does that require a petition where it would say, he's on title and husband of so-and-so? If she were to pass, that requires petition then? Okay.
Yeah. Yeah.
Thank
Yeah.
you.
It sounds
Jessica-
like land court is very cumbersome, but it's actually a very safe, because as you can hear,
Mhm.
they scrutinize everything.
Hey, Jessica, this is something that I've had come up with some of the newer agents. So if you could address it, when we request a comp prelim as we're working on getting a listing, Two things. What kind of time frame are we looking at there? And second part, is there a difference between that first prelim, the one you pull quickly, and the one that would come later when we went into escrow?
Yeah.
Anything that they should be looking out for?
Right. Yes. Well, let me answer the second question first. So the difference between the comp and the full report is you're not so much concerned on what affects the property anymore. All you're really looking for at that point is if anything new has recorded since the time that comp prelim was issued.
Okay.
And on the full report, it'll also do searches on the buyer as well,
Okay, right, yes.
because you now have a buyer.
Yeah.
As
Which
far
always
as,
freaks the buyers out. It's like, what are they looking at me for?
yes, yes, exactly. And you know, it's a good thing that we are, because you may be aware of liens against you or you may not. But what you don't realize is when you purchase that piece of property and it's cash, that lien is going to affect it immediately.
Yep.
Right? You're not required to if it's cash purchase, you're not required by anybody to have that lien removed if it belongs to you. But just know, as soon as you are that owner, that encumbrance is affecting that property. Timing of reports, that's another good question. We've hired, yay, we've hired and we're training new searchers. So our turnaround times on reports are getting better. And in the future, we're also getting a system that'll make us move faster. So right now, we're trying to keep to a 5 to 7 day time frame.
Okay.
In the near future, we're hoping to cut that down to much quicker.
Okay.
Yeah.
Great. Thank you.
You're welcome.
That was a loaded question, Gary.
Put me on the spot, Gary.
Yeah.
Well,
It has to do also with the last date of transfer, right, Jessica? If there was a recent transfer, you guys can turn the title report real
Correct.
quick.
pretty quick.
But if it's a long search, yeah,
Correct.
they take a while.
And honestly, I think everybody's felt the slowdown, and it's been weird things that we've been selling. So some of these reports are taking much longer because we have to go so much farther back, you know.
It was actually Bobby set me up on that. I got to throw him under the bus. Huh? You don't know? No, I guess it wasn't you, Bobby. That was me.
So if there's nothing else.
Hey, Jessica, you brought it up earlier, but real quick, you mentioned that, you know, when the property is owned in trust, that when the sale closes, the proceeds check is actually made out to the trust.
Yeah. Good question.
So I just dealt with that with one also. So is there things that you guys recommend that we agents go and talk to their clients and say, hey, you know, if it was on mom and dad's trust and mom and dad passed away and you don't have rights to an checking account or a bank account with their trust name, they need to get that done ASAP with their attorney, because yeah, we've had several situations where we close escrow, escrow sends the check to the seller and the seller can't cash it and they can't deposit it, and they get mad at us because we didn't inform them of that. So yeah.
Yeah, that's correct. No, and that's another, we can start a new subject on that too. So there's different types of trusts out there, right? You have.
But is there any way that we can provide documentation to you folks to avoid that? You know, if we provide a copy of the trust showing that this person is the successor trustee, and is there no way around that on your side to get the proceeds made out to the heir?
Yes. So this is a touchy subject. So most people do not want to give escrow their full trust. There's a lot of confidential information, a lot of private things. But if we are given enough satisfactory documentation to show, it's a simple review by our legal department. If it's Jessica and Glenn's trust, we're the trustees, we are the beneficiaries, right? If we can show those pages to title, to our legal department, they could approve it, where then the proceeds are made to us as individuals versus our trust. When it's a mom and dad trust, son is successor trustee, now there's different beneficiaries and heirs under him. So the trustee, their rights are to allow them to sign on behalf of this entity, right? So once you get deeper into that kind of trust, then it's harder to get an approval by our legal department to say, yes, those proceeds can be made payable to the individual versus the trust. So a suggestion would be, when you're taking a listing and it is in trust, mention to the sellers up front to be sure that they have a trust account set up to receive these proceeds. And it's very common that this is the only property that they have in trust. They've never sold before in trust, so they don't have an account. And they're not aware that the proceeds are going to be made payable to the trust, right? So giving them that heads up, making sure that they do have a trust account that's ready on the other end to receive the proceeds is very helpful. And sometimes it's as easy as speaking to their bank and adding the trust to their existing account, right? You don't have to necessarily open up a new account for the trust itself. Certain banks will allow you to add your trust to your existing individual account, if you're lucky. Yeah, good question. Any other questions?
Jessica, I have a question about the trust company. I'm not familiar about that. So if one of the trustee is died, passed away, but doesn't need to do any petition, or just trust company is a trust company and then any trustee can sign?
Right. Yeah, simple answer, yes. So with the trust, it's an entity. It'll list who the trustees are and who the beneficiaries are. It'll also list who the successor trustees are in case of the death or resignation of the original trustees. So the simple answer to that is yes. There's no petition needing or anything special needed there. If it's, I should take that back. There's nothing special needed if it's regular system, right? But if it's land court and title was originally signed by the original trustees and now there's a successor trustee, then there's a petition needed to show the successor trustee's right to sign on behalf of the trust. If it's regular system, we just need to see that clear trail of who's now allowed to sign on behalf of the trust.
Yeah, so the land code is more strict, like to prove everything.
Yeah.
Okay, thank you.
Exactly. You're welcome. Anyone else? No? You guys are great. Thank you for not putting me on the hot seat too much. I appreciate it.
Awesome. Thank you. Thank you,
Thanks, Jessica. That was
You're welcome.
very informative. Really well done.
And if anyone does come up with any other questions, we're always here to help at Ho'okele, so please don't hesitate to reach out. Your go-tos are all on this call, myself, Jessica, Kanani, and Gray over on Maui. So just give us a call or email and we'll get that answered for you.
Hey, where is the recording going to reside? On Bay somewhere or?
Great
Not
question,
on,
Gary. We'll have it. Sorry, I apologize. I didn't mean to jump in. Gary, great question. Our marketing team will go ahead and host it on YouTube, and we'll have a link to that in a few days after we edit it, and it'll live on YouTube, so that way we can always go back for it.
Cool.
Thanks, Greg.
thank you again, Jessica. And thank you everyone for spending your morning with us. We hope you enjoyed it. And again, happy Aloha Friday. And then again, as Jessica mentioned earlier, this topic was a request out of the Gila office. So if anyone else has any topics they would like covered in the future, just go ahead and let me know.
Thanks, Jack. Bye.
Anytime. Bye.